To continue with the theme of this year from the risk management department, the back to the basics, we've been, removed from the workforce on some level for the last couple of years, really getting back into it. We're going to continue on that topic and focus on liability today for the next hour and 15 minutes, depending on how talkative you guys are. And then we'll wrap it up with, I think Jason is going to host the hot topics discussion when we finish. So we'll start with what is liability? What causes liability? What's the, when our district's liable? So, there's a lot of different words that get thrown around, whether it's one of the ones on the screen or tort, right? When somebody files a tort notice, they're notifying us that they intend to sue us in court. But the majority of the time when we're dealing with liability in our districts, especially when we're talking about an injury, to a patron or damage to their property, negligence is what typically comes into play. The first one there is intentional conduct. So an intentional tort, that would be us knowingly doing something wrong, like walking up to your patron and punching him in the nose for no reason, right? Or purposely sabotaging our system, breaking a water pipe to cause damage to somebody's property. Those don't come up too often, when we're talking about liability with our districts. But the negligence piece does. And in order for negligence to exist, there's really 4 components that have to be present. First, we have to have a duty that we owe to that claimant or that patron or that tax-paying citizen. We have to breach that duty. There has to be a loss, and that loss has to be directly correlated to the breach of the duty. So, for example, a irrigation district has a duty to have water stay in their ditches and not breach the ditch, right? If they're not doing maintenance, not doing inspections, and that ditch breaches and floods somebody's property, we have all 4 of those components, right? We have a duty that we owe to the member. We didn't maintain the ditch. We breached that duty by not doing inspections, not doing maintenance. We had a loss, we damaged their property, and it was directly related to the breach of duty that we had. So that's an example of what negligence would look like. The last one there is strict liability. I don't think this comes up a ton with the claims that we deal with, but that is undertaking an inherent risk where we can't get out of liability. If something bad goes wrong, we're going to be liable because of the inherent dangerous or hazardous nature of that work we're doing. A good example of this would be somebody that's using dynamite to drop a building or something like that, right? It's so hazardous, you're going to be liable if something goes wrong. So when it comes to our claims, we wanted to give you guys some samples of kind of, what are our high frequency claims and where are high severity or high costs associated with claims coming from. We're going to end the presentation with a couple of case studies from a variety of districts, none of which are in this room, which is kind of unique. So we'll, give you guys kind of a view of where some of the exposure comes from other types of district. But you can see on the frequency standpoint there, distribution. So talking about water systems, this is broken pipes, broken water lines that have caused damage, caused sinkholes, caused car wrecks because of the sinkhole, those types of situations. Irrigation, districts, whether it's, again, breaching, the example I just used with negligence, flooding somebody's property. We even deal with it recently. We're dealing with, some claims associated with not having water. Patrons suing for not distributing water because of whatever the reason is. We're seeing a lot of that in Klamath. I just was doing a claims review with an irrigation district last week that had a couple of farmers file a claim because their pump burned up and they didn't deliver water and they lost their crops. So we see a lot of different claims associated with our irrigation districts. Pedestrian hazards, or, a lot of times we'll refer to these as premise liability issues. trips and falls, whether it's a sidewalk or, a extension cord running across where your patrons, your guests to your property are walking, they trip, they fall. We deal with a lot of those. And then the last two there are associated with employment practices related matters, typically harassment, discrimination, hiring or retention. And if we jump over to the severity side, you can see that those are our most costly claims as well. And we'll talk a little bit why those are expensive here in a few minutes. You can also see that the irrigation district, some of those, are more severe, more costly than other types of claims. And then standard of care being violated. This could be a couple of different things. Often when they're coded this way in our claim system, it's dealing with our emergency services where they haven't followed their standard operating procedures on some level, their medical directives. So a lot of times it's medically related, but it doesn't always have to be. Standard of care could also be that we aren't up to industry standard in that area, whatever that might look like. If it was a park and rec district, standard of care potentially could be that our playground equipment wasn't maintained to the industry standards. So we're going to have a chance to be more liable for a situation like that. And it looks like whatever happened online, we just got a flood of people. So thank you for joining us. I apologize that there was some sort of technical difficulties. We haven't gotten too far in, so I don't think you've missed anything too critical up at this point. For those that are attending virtually, if you do have questions throughout the presentation, please feel free to put those in the chat box, or you can raise your hand using the raised hand feature. And when we get to a spot, Dan will let me know, and you will be able to unmute yourself and verbally ask questions if you would like. And then the last one there from a severity standpoint is our sanitary districts having some sort of issues with the sewers, whether pumps go down, we have broken pipes, we back up into somebody's residence. Interesting. Anyhow, doing some sort of damage due to sewer backups is another costly claim that we have a tendency to deal with. So in Oregon, we do have tort reform in the form of the Oregon Tort Claims Act. This was put into place, I believe it was in the 60s.
1967.
1967, thank you, Dan. Really to protect public entities. Prior to that, in the state of Oregon, you could not sue or file a claim against a public entity. So that was, essentially found to be unconstitutional under the Oregon Constitution, and the Tort Claims Act was developed, and it's really been modified over the years. When it was first put in place, a public entity could only be liable for up to $200,000 for a personal injury or loss and up to $50,000 for a property loss. That was the case even when I first started in the risk management world. I believe it was right around 2008, 2007, 2006, somewhere in there. Clark versus OHSU basically got the tort caps thrown out as being not constitutional because it wasn't a substantial remedy for that case. The legislature took that back up and made some changes, some tweaks to the caps that we see today, which you can see there on the screen. So on the liability side for a personal injury, the cap is set at $806,000 for an individual, and twice that if we have multiple individuals from a single occurrence. So ideally, the hope is your largest liability exposure for a claim brought in state court is $1.6 million. On the property side, you can see same type of occurrences for a single individual and a single occurrence. It's $123,000. For multiple individuals on a single occurrence, it's $661,000. The other thing that the Oregon Tort Claims Act does for public entities and its officials, its employees, volunteers, agents, board members, is it requires the entity to defend and indemnify their employees, agents, volunteers, all the people I just mentioned, as long as you are acting within the course and scope of your duties. So if you're within the course and scope, your entity has to defend and indemnify you, which is nice, which is the way it should be. If it is not a tort cap buster, and it falls under the Oregon Tort Claims Act, if you're named individually as one of the defendants, we can get those thrown off. We can get you removed, get you replaced with the district, and that frees up your life to buy your house, buy your car if you're in the process of doing that, because it can cause some difficulties there. So also associated with the Oregon Tort Claims Act is discretionary immunity. And, you know, this is, I don't refer to this as a true immunity. It's really a defense we can use if our claims staff choose to use it. And they're going to look at those circumstances. But essentially, being a public entity in the state of Oregon, if you use your discretion, we have this as a defense. Typically, these types of situations are, we know that we have a hazard of some sort. We can't afford to fix it tomorrow. So we have somebody take executive action, usually at the board level, to say, hey, we know we have this problem. We can't fix it right away, but here's our plan of action. Here's how we're going to address it. Here's how we're going to budget for it. And we'll talk about an example of that here later on in the presentation. The other immunity that also is a defense tool that we can use is recreational immunity. When we have individuals, the public, coming onto our property to recreate, we have a defensive immunity under this statute as well. And this isn't just park and rec districts that have used this or could use this. I know we have a fire district that Jason worked with, that they have fishermen that walk across their property to get to the river. This is a defense we can use. It does not apply if we charge for use of the facility. The caveat there is we can charge less than $15 for parking, and that would not eliminate this from being used, as long as we are clear that the fee is for parking and not for the use of the facility that they're at. If that is something that you haven't dealt with, you're charging for parking, you want to make sure you're doing it right, give us a call. Let's have a conversation about the situation, and we can make sure that we have that documented and we're doing the right thing. So other legal defenses that we have in Oregon, one is contributory negligence. So, we can look at, our claims staff can look at who's more at fault. And if we're more than 51% at fault, but we're not 100% at fault, we're not liable for that whole amount of damages. So that is a defense we can use. Assumption of risk is another defense. Patrons that are coming on to your facilities, attending your events, whatever that might look at. A good example is a park and rec district. We have a baseball game going on. There's some inherent risk going to a baseball game. There could be foul balls, right? So we can use that assumption of risk. And then the community standard of care, really talking about what is the industry standard, or we're up to that industry standard. We can use that as a defense if somebody files suits or files claim against us. So just for fun and kind of to highlight why we don't like taking cases to court and we settle often, we've just sprinkled in a couple of these absolutely ridiculous jury awards, just to kind of lighten the mood a little bit, but also just to highlight, you never know what's going to happen when we go to court and you put a case in front of a jury. So in Austin, Texas, a woman was awarded $780,000 by a jury of her peers after breaking her ankle tripping on a toddler that was running amok inside a furniture store. The owner of the store was understandably surprised at the verdict, considering the misbehaving kid was the woman's son. There's always a little bit more to the story than what you get in these clips, but every liability claim that we deal with is going to be taken on its own merits. And liability is very gray. It's not black and white. More than once, we've had two claims that look identical on the surface and one we're liable for and the other we're not. And it's just going to be those little tiny nuances that come into play. So when we are dealing with claims, specifically lawsuits, there's a big difference between federal claims and state claims. A lot of the lower severity lawsuits we deal with are going to be state claims or in state court. But a lot of our large losses, those that we saw on the severity side of that claims chart that we were talking about, are going to be federal claims. And when items are filed in federal court, we no longer have the protection of the Oregon Tort Claims Act. So as I was mentioning, you know, $780,000, 1 point, just over 8, just went up.
806.
806. 1.6 million if there's multiple claimants for that occurrence. Those aren't in place when we are in federal court. The other side of that is if it's a civil rights claim at all, so typically anything employment practice related, that's the majority of these claims. If there is any jury award at all, we have to pay the attorney fees for the other side. And we've had more than one occurrence where we've had a judgment against us. We decided to take it to court. They weren't willing to settle for what we thought it was worth. And we felt very strong, but you know, you get one little nick on you and the jury awards them $10,000 of the $2 million prayer. And now we're stuck on the hook for all the attorney fees for both sides, you know, so that $10,000 award is now a $300,000 or $400,000 claim. So that's how those get so expensive. So a little caveat here, most of our members know this, we've been preaching this for a long time. Employment practices claims are our most expensive claims. They are really one of the driving cost factors for the liability program. So we want you to reach out to our pre-loss legal folks, to Tanya Grass, to Spencer Rockwell, to Ron Downs, if you are planning on taking a negative employment action. So prior to taking a negative employment action, you are required by your coverage documents to reach out, seek their advice and follow their advice, or you have a $25,000 deductible if a claim or a loss stems from that negative employment action you take. I used to say that's our carrot, that these are really expensive claims. We want to be involved early. I've had more than one person tell me that's not a carrot, that's a stick. So whether you think it's a carrot or stick, it's our incentive that we just want to be involved in those early on. If you're already using an attorney, you have your own retained general counsel, just make sure they're reaching out. You know, a lot of times it's just a quick phone call, a few questions and give you the thumbs up. But on the other side, it's also a good judgment check. And it might be, whoa, let's slow down. And we need to make sure we get this documentation in place. We need to, you know, go through the due process requirements if you're going to take that negative employment action. So just going to kind of run through some of the hazards of some of the claims that we deal with, some of the conditions that cause liability exposures for our districts. And some of them, it's not just liability, right? We can all look at this parking lot and go, wow, that's in poor shape. But what types of losses can you expect from this? Reaching out to the group. What's that? Vehicle. So somebody damages their vehicle because the parking bollards are broken, damaged. What other types of claims might we deal with?
Personal medical.
What's that?
Personal medical.
Personal medical. So trips and falls, right? And those are really the two primary ones, but very easy to remedy this, right? If they were really in this bad a condition, I would rather see them gone. Let's remove them from the premise or replace them, bring somebody in to pour a curb. But the other issue here that we're not talking about, we covered property, I think 2 sessions ago, is this is ripe for causing property damage. Vandalism to your property, right? Crime of opportunity. Hey, there's this chunk of concrete that I can throw on the roof of your building. You don't find out about it right away yet. It cut a hole in the membrane of your roof material, or, you know, broken window or whatever it might be. So a couple of different reasons why you might want to get rid of that. This is a very typical irrigation district. you know, there's a variety of concerns associated with this, from employee safety, working over water, not having railings. But from the liability side, we also have a lot of exposure. Most of these facilities are on private property that we have easements to. But if a member of the public was able to access this area and they fell off of, you know, this walkway, or it could be they, you know, fell and impaled themselves on the post that's coming up of those gates that's not protected, you know, we could be potentially liable for those situations. So, you know, making sure that our facilities are up to industry standard, that they are safe for our employees. If they're safe for our employees, they're probably also safe for the public if they happen to access those areas. Sidewalks, you know, I said I was going to mention a sidewalk one later when we're talking about discretionary immunity, because it's the easiest example. You know, if you went out and all of your sidewalks look this way and you had a large facility, you know, it might be a $30,000, $40,000, $50,000 bill to get those sidewalks repaired if we've neglected them over the years. And unfortunately, a lot of people don't think about this till they have that first loss, you know, and I've seen $40,000, $50,000, $60,000 claims associated with these types of hazards where, you know, we have somebody that's more elderly that trips and falls, breaks their hips, and they're really expensive. So if this is a situation you might be dealing with, you know, having your board take action, acknowledging that, hey, our sidewalks are in poor condition, we need to repair them. You know, we went out for RFP, it's going to cost $45,000. We don't have that in the budget. And then the board setting a plan. We're going to budget $5,000 a year, $10,000 a year to do sidewalk repair and replacement. And we're going to start with the worst first, and we've documented that list. You know, at least if we have a future claim that comes from that, our claim staff has the option to use discretionary immunity as a defense. You know, again, they're going to look at all the facts of the case, decide whether or not that's a good way to use that or a good defense for that situation. But we're better off in that situation than a district or a board that put their head in the sand and went, yeah, I know we have it, but we can't afford to fix it. We're not going to make a plan. We're going to, you know, act like we didn't know about it. That's going to put us behind if we have a patron or a member of the public that's injured and files a claim. Another just good example of something that could cause liability for a district. This is exposed electrical, you know, a light pole that's missing a cover for one reason or another. Obviously, we can all look at that and go, yeah, we need to fix it. But it highlights the importance of doing inspections of our facilities, identifying these, and getting them repaired as soon as possible. On the frequency side, we see all too often these types of barricades, whether we're trying to keep vehicles out of a certain area or directing patrons to walk a certain area in low light conditions. These are very difficult to see. You know, we've dealt with claims where cars have run into these. We've dealt with claims where people have tripped over them, even where young children have ridden their bike, you know, right through them, and it's caught them around the neck or the chest, and caused injury. So if you have any barriers that are hard to see, we just encourage you to make them more visible, whether it's improving lighting in that area during low light times and, you know, painting them a luminescent color, putting some sort of a bright hose over them, hanging placards, again, to make them more visible. There's a variety of options to help reduce that exposure. Here's kind of a no-brainer, right? Trip hazard inside our buildings. You know, we have extension cords running across walkways, or power strips that are running across walkways. Obviously, you know, we could talk OSHA compliance issues, we could talk employee safety, but if it's where your public also access, we have that potential liability exposure that goes with that as well. This is just a hole in a field, whether it's a park district or somewhere else. I mentioned that we have recreational immunity available, if we have the public recreating on our property, that we can use that as a defense. But if we have a known hazard, we need to notify the invitees of that hazard. So this would be an example. This, if we knew this was there, or we should have, a reasonable and prudent person would have known it was there, or we should have been doing inspections. It's really going to cause more liability, rather than, doing our inspections of our facilities, coning off that area, getting that hole repaired. In fact, this is a good example of, there was a case, I don't know how many years ago now, 5, 6, 7 years ago, that recreational immunity essentially went away for a short period of time until the legislature put it back in place with some changes, or it could have been case law. I don't remember all the details, but an individual was jogging up on the Portland waterfront and tripped in a hole like this. And the city of Portland tried to defend with recreational immunity. And there was some significant negligence involved from my recollection. And that wasn't a good defense. And we almost lost it for every public entity in the state. Actually, recreational immunities for public or for private too. I do believe. Another just kind of no-brainer, we have aisleways marked as keep clear, and then we put stuff in them. So again, if public can access that area, trip hazards, those premise liability exposures. Bleachers, park and rec districts typically are, where we're going to see these, but these bleachers might have been great 30 years ago. But now industry standard, that standard of care, is that any bleachers that have a seating or footboard more than 30 inches off the ground need to be protected from falls. The Consumer Product Safety Commission actually publishes a retrofitting guide for these styles of bleachers that we can go in and retrofit to help reduce that exposure. And we've had some significant claims. I can recall one where we had a toddler that fell off some bleachers and spent multiple days in the ICU. So these aren't necessarily small, insignificant claims. Some of them can be very, very severe. So another kind of fun one. A 19-year-old of Los Angeles, California, won $74,000 in medical expenses when his neighbor ran over his hand with a Honda Accord. The injured man apparently did not notice there was someone at the wheel of the car when he was trying to steal his neighbor's hubcaps. I think that one was probably pretty old. I don't think very many cars have hubcaps anymore. But, so from the prevention side, a variety of things we can do to help prevent, reduce, mitigate those liability exposures. When we're talking about the premise liability type stuff, inspections are key. Training our staff to always be paying attention for hazards associated with your facilities and putting repairs or fixes in place to reduce those exposures. It's good practice. Our claim staff, our attorneys love it when it's a documented process, however that might look, even if you don't find anything wrong. When we can prove that, hey, every time we're at this facility, we're looking, or once a month we have a formal process to walk this facility, inspect it, we document it, and we had no notice that this hazard was present because it happened in between our formal inspection process. Signage could help. I mentioned, that we have a duty that we owe to people when we have a known hazard, right? Putting a sign up is one way to do that. Playgrounds, it's great to have a sign saying, hey, this playground equipment is rated for 5 to 12-year-olds, 3 to 8-year-olds, whatever that might be, so that there's information there. We get a lot of questions on signs. And I would just encourage you to reach out to us. I know our claims manager has some very strong opinions on signs. He'd rather see stuff like no trespassing rather than no swimming, on an irrigation canal or, that kind of stuff, because no, it's just no trespassing. There's a hazard beyond this point. You shouldn't be in there. Or if we say no swimming, You know, are we saying this is now making this an attractive nuisance potentially, or, you know, causing some sort of other exposure? Another one we get often is helmets, park and rec districts that have a bike trail or pump course or something like that. Should we require helmets to be worn on the signs? Well, if you're going to require it, you have to enforce it. You know, and if you have notice and you're not enforcing it, does that cause more liability for us? And potentially, again, it's a very gray area, but we'd rather you know, if you're not going to strictly enforce it and take action on it, it should be strong recommendations that, hey, you should be wearing this protective equipment, or here's the hazards associated with accessing this area or participating in these types of activities.
Justin has a question. So if Justin wants to unmute yourself, you can ask your question.
Oh, yeah, I was just writing notes and I forgot to write down what that minimum specification was for bleachers for when fall protection is required.
Perfect. 30 inches.
30 inches. Perfect. Thank you.
Yeah. And Justin, if you do a search, a Google search for CPSC, Consumer Product Safety Commission bleacher retrofit, you should find the federal government's pamphlet on that, which will probably be helpful.
Perfect.
Great question.
Or we can send it to you.
Or we can send it to you. Email Greg. I think Justin's with Ben in Park and Rec. So Greg's his guy out there.
Yep, that's right. I was actually just talking to Greg this morning about signage too, so I appreciate your bit on that.
Yeah, absolutely. So further from the prevention is just our regular maintenance. You know, it kind of goes along with those inspections, right? We assume if we're inspecting our facilities, finding issues, we're doing that maintenance. But, you know, whether it's maintaining a trail, maintaining a walkway, maintaining our parking lot, maintaining our buildings, you know, walk-off mats during the rainy season, you know, just those regular maintenance items that can help reduce those hazards, reduce those exposures. TULIP program, TULIP stands for Tenant User Liability Insurance Program. If you're not familiar with this and you allow your facilities to be used by outside groups or parties, from a best practices standpoint, from a risk standpoint, anytime the public is using your facility for a private event of some sort, there's a variety of things we'd recommend, but to keep it shorter, you should strongly consider requiring that group to provide you a certificate of liability insurance, naming you as an additional insured. That's not always feasible or not always what a district wants to do, but that is definitely the best practice, because you know, if something happens while that group's there, should you be liable if it's a private event? And then should your tax-paying citizens be paying your increased insurance premiums for that loss occurred that wasn't associated with any district activity? Obviously, we'd also encourage you to have, you know, a good facilities use agreement in place, a board policy kind of outlining who's allowed to use it, who's not allowed to use it if we're going that route. And there can be some exposures created with a policy like that if we are not equitable in who we're allowing to use our facilities. If you're opening your facility for anybody to use, you need to open it for anybody to use, and there can be unintended consequences. I think there was, if I remember, it was the city of Cascade Lock, City of the Dalles, somewhere up on the gorge. This was, I want to say early 2000s park. I think it was a city, but it was a city park. They had a facility use agreement, and a white supremacist group came in for a rally, wanted to use their park, you know, and you really can't say no necessarily. You know, we'd want you to get in contact with the attorneys at that time. But, you know, so facility use TULIP program is a program where if that group doesn't have their own liability insurance, you can hand them this brochure that you can find on sdao.com, and they can purchase event insurance for that activity that they're doing. You can go in there and play, input information, and kind of get an idea, get a quote of how much those are going to cost. I think they're very reasonable for an actual activity. If it's a group that's sitting in a room and knitting or just having a meeting, okay, it might not be as feasible. It might still cost them $100 or a couple $100 to get that insurance for something like that. And then I also already mentioned our pre-loss legal department when we were talking about employment claims, but obviously they're a great resource. Anything that we could potentially be liable, the insurance program would have exposure on. Typically, we're going to help you in some fashion, providing you some assistance, guidance, pointing you in the right direction for those exposures. And the best way to get a hold of our pre-loss department is help@sdao.com. That goes to Tanya, the paralegal in the department, and then she kind of divvies that out and sends it to Spencer or Monica or Ron, depending on what the topic is. So some general risk management principles. From a generic standpoint, we have a pre-loss model or a post-loss model. Obviously, we would love it if all of our members were really looking at the pre-loss model. Before we have an incident, what are things we can do to mitigate that exposure, mitigate that liability, rather than being reactive to it? Oftentimes when I'm dealing with entities that want to undertake a new activity, whether it's a soil water conservation district that is looking at taking over or starting a camp, a park and rec district that's, wanting to do whitewater rafting or rent out, inflatables to float the river. I guess it could be a variety of things, but I often ask the manager that's overseeing that, if you have a bad loss, are you going to stop doing this activity? And if the answer is yes, why are we undertaking it to begin with? We shouldn't be waiting until we have a loss to go, oh, maybe we shouldn't be doing this. And that's really the emphasis of the pre-loss versus post-loss model, right? We don't want you to be reactive. We want you to be proactive in looking at where these exposures are at within your district. The risk management department is here to assist you with identifying those risks, whether it's coming out and walking your facilities, having conversations about best practices related to activities or job operations and how we can mitigate those losses. Another area of safety that we often talk about are the 3 E's. Is there a way when we have a known hazard, the first thing we always want to do is there a way to engineer that hazard out? Whether it's putting a guard in place, limiting access to that facility or that area, but somehow really, putting a barrier between the hazard and the public or the hazard and the user. And if that doesn't work, we want to look at educating. From an education standpoint, how can we mitigate this hazard or mitigate the risk of loss associated with this, whether that's a public education campaign, a sign, those types of things. And then last, we want enforcement. We've set an expectation. We talked about signage earlier. If you're going to require bicycle helmets to be worn on your pump track, we need to enforce it. If it's just a recommendation, we strongly encourage it, then we don't have that enforcement side. And then we can look at whether we're transferring the risk or retaining the risk, right? Those higher risk activities, we love it when people transfer that risk to a third party, contract out, a job operation because we've dealt with bad losses or we don't want to assume that risk. It's beyond the risk tolerance of your district. Insurance is also a risk transfer, right? From a financial standpoint, you purchasing or participating in the self-insurance through SDIS, that's a risk transfer. You're transferring that to the other 950 special districts that participate in that program versus retaining that risk. This is our core business. We know what the risks are, and we're going to take on those risks because that's what we have to do to provide the services that we provide to our public. So another fun case in Pennsylvania, a man was leaving a house. He had just finished robbing. He was doing so by the way of the garage. He was not able to open the garage door because of a malfunctioning door opener. He couldn't re-enter the house because the door connecting the house to the garage locked itself when he pulled it shut. The resident of family was on vacation. He found himself locked in the garage for 8 days. He sued the homeowner claiming that the situation had caused him undue mental anguish and was awarded $500,000 in this case. So after we have an incident, we have some sort of loss, you know, we should always be doing some sort of review or an investigation. And primarily the three reasons why we want to do that is we want to learn what happened and make sure that it's not going to happen again. We should also be doing it to make sure that we have accurate data, whether it's photos, whether it's diagrams, measurements, components that were involved. We want to make sure we have that information and it's accurate so that we can provide that to the claims staff so they can do the best job at determining liability associated with the incident. And then obviously, and I think I just covered that, documenting accurate information up front. So what are some of those things that we'd want to make sure that we document? And I think one of the key things to remember here with, especially with liability related exposures, is you want to document this clear enough that 2 or 3 years down the road, you're going to be able to remember what those facts were. Because if this is something that ends up in court, usually that's not just next week or next month. You know, it could be 2, 3 years down the road where you have to testify if it ends up going to trial. So, you know, when we have that incident, we want to preserve that incident scene as much as possible. It might be taking photos. The example here that we have for a photo is of a car wreck. And I know that Jens has asked us to reach out to members more than once on, hey, when you're taking photos of a car accident scene, we don't need that up close front corner right where the damage is. We need the overall view. Where were the cars sitting? What does the intersection look like? You know, the damage of the vehicle. Give them a high quality photo from a corner so that they can see the overall, how much of the vehicle is damaged. They're able to zoom in on those. But make sure that you're getting different perspectives, different angles, you know, and I'm talking, you know, the example here was a car accident, but it should be no different. You know, if we have a trip fall injury out on our sidewalk, you know, get photos from a couple of different angles, get a pin next to, you know, something that's a known size so we can compare that. Hey, how tall is that sidewalk where it's bumped up from that tree root, or a tape measure, or a yardstick, whatever you might have. If there's any witnesses, make sure you're getting all their contact information. Again, might be a couple of years down the road before you end up in court on this, and we want to make sure that we have enough contact information that we can figure out where these people are at if we need them to testify. You might pull, if you have inspection files, inspection records, whether it's your safety committee, whether it's your maintenance folks, pull those, make a copy of them, throw them in a file with this incident report so you have all that data all in one spot. And of course, this isn't an accident investigation class, but once we've gathered all that data, we really want you guys to analyze it, do a root cause analysis. Why did it happen? How can we prevent it from happening again? And what actions do we need to take? What corrective actions should we be putting in place to make sure that doesn't, that we don't have a reoccurrence? So we're going to move into some case studies, and I'm glad we have more people, because hopefully we actually have the types of districts that we're looking at these case studies. So this is going to be a more interactive section of the presentation. So for those of you online, I'm going to ask that you guys get your chat box open. So we have an irrigation district, and they had a canal that failed. It ends up flooding a home and doing damage to some landscaping. So if you were the claims adjuster or the operations manager for this entity, what information or questions would you want to ask to investigate this occurrence and what happened? So go ahead and put that into the chat box. And we're gonna ask the people in our live studio audience to chime in here in just a minute. And yes, I can wait you guys out.
Yeah, we got no place to go.
Why did the canal fail? Yeah, that would be a good one. When was the canal last serviced or maintained? Another great question. How about anybody in here?
It was last inspected.
When was it last inspected?
Intentional damage.
Was there intentional damage done to the canal? Were any interventions exercised to stop the flood? So those are all, guys are all on the right page. So, here's what I had listed, not that this was all inclusive. Were there regular documented inspections? Did they clean the canal so they could see the hazards? Did the homeowner modify the canal? Because that could really change whether or not we're liable. A lot of times we're not going to be liable for seepage where the water is hitting the hard pan underneath and seeping out. And then easements sometimes come into play. As I mentioned earlier on, when we were looking at some head gates for an irrigation district, a lot of times those are on private property, so we want to make sure we have good documentation of what the easements are like. So we're going to just look at some different concerns with some of the facilities we've been out to over the years. This is a dike to help prevent flooding, so it's keeping water in one area. Anytime we have irrigation banks, dikes, diversions of sort, we want to see those bare and clear. No vegetation other than grass, no trees. That way we can actually see what that earthen facility looks like. We know whether we have vermin digging holes, creating, issues that we need to work on. If we have trees growing in that area, where do you think the roots want to go? Right towards the water. And now we're creating passageways that can cause failures. Here's another area where it's just washing away. This is where regular preventative maintenance, this one's from a different angle. You can see that we have sloughing. This is an area where we need to come in and do our preventative maintenance. This is another key why inspections are important, right? If we're not out inspecting our facilities and we don't know this is occurring, this is right along a roadway. Do you think we could be liable if there was an accident associated with the sloughing here? It's good chance. Really, they probably need to put some riprap up, get some rock in there.
So question, so this picture will kind of work with it too. So when we talk about the indemnities, there was no act of God indemnity. How do those acts play in? This could be a result of high rain, wash that bank away. You could have a lightning strike. How are those things addressed?
It's all going to be dependent on the situations of your event. So let's take this for example. This occurs overnight and we have a car wreck because of it. There's a lot of questions I want to ask. Have you had issues right here before? Should you have known that this area of the bank was going to fail? Have we done, any preventative maintenance, building up with riprap, larger rocks? If the answer is no, we've never had any issues there. We had no notice that we were going to have a problem. There wasn't a weather alert that we should have been out looking and watching for this stuff. No, we're probably a little less liable than if the opposite was to occur. Lightning, being a PUD, should your system protected from some over voltage, a power surge, all of those things, did you have the components in place? Were they functioning properly, or was it a failure due to the lightning strike? There's going to be a wide variety of reasons why you could or might not be liable, but it rarely is it black and white and I can say, yes, every lightning strike is going to be covered, or no, it's not. If that, does that kind of answer your
Yeah,
question?
there's just nothing that really covers acts of God, weather, events, things like that. It's like I can't control a tree falling, things like that.
No, but that notice, you know, or the one Dan always uses, a reasonable, prudent person would have known that, hey, that tree has been dead for 2 years and we haven't addressed it. Yeah, there's a better chance of it falling, and you're taking on more liability exposure if you haven't addressed that in some fashion, in my opinion.
Okay.
You guys have anything more to add?
I'm just thinking of recent events with wildfires. So we had public safety shutoffs, which create their own political
Right.
firestorm, right? Generally, you're looking at what the maintenance of lines would be. And for your specific instance, there's standards that are in place. And I think if you can point back to, here's the standards that we followed, we're in compliance with, with those best practices. That's a good defense at this point. So, in the case of the public safety shutoffs, were you a part of that discussion? Did you guys inspect, plan for those things? If you didn't follow through on those, what was the reasoning behind it? Being able to explain yourself is really important. But I think going back to the standards that are out there, NFPA standards, NEC standards, there's a lot of different groups who offered opinions, and sometimes we choose to not follow those pieces of advice for whatever the reason might be. So,
Well, it's funny. Because you want to talk about gray areas, the public safety power shutoffs we had around here, thank goodness I wasn't affected, thought I might be, but it was the forecast was for it to be 100 degrees out. Now you're doing these power shutoffs. Are you causing some potential liability for somebody that has a susceptibility to high heat? That now you've taken away their power to have their air conditioning. And if we worked with community groups to provide cooling shelters, if that's a circumstance, and that plays right into it. It's funny because I have a generator, for my house. Guess what? My air conditioner is not hooked up to it. Power outages usually occur in the winter, not in the summer. But great question. Thanks, Nate. I think this is the last one on irrigation districts that we'll use. This is what we refer to as a last chance cable. Oftentimes these we'll have these placed upstream of where, a irrigation ditch or canal goes into a pipeline or some other sort of hazard. So kind of a last ditch effort to provide a resource for somebody that's in that water to be able to grab and get themselves out, Last chance cable, that doesn't mean this is the only notice they got, right? We have some sort of signage, fencing, to keep people out of that area to begin with. Because this is what we don't want to have happen. And I think we had a big incident before my time. It was actually I believe it was a sanitary district up on 84 that they had their lagoons that breached and ended up flooding several properties similar to this. All right, in Arkansas, a plaintiff was awarded $14,500 in medical expenses after being bitten on the buttocks by the next door neighbor's beagle. At the time of the bite, the beagle was on a chain in the owner's fenced yard. The award was actually less than sought because the jury felt the dog might have been provoked by the plaintiff, who had just prior to the bite was shooting the dog repeatedly with a pellet gun. Again, I know there's more to these stories, but we never know how a jury is going to react. So our next case study, a pedestrian trips and falls on a raised concrete sidewalk, and it was raised caused from a tree root, has a couple of facial fractures and unable to work due to the injury. So back to you guys online, put in the chat, what's the questions or what information would you want to help you investigate this occurrence? I'm going to have you read them out if I can't.
Can't read that fine print.
Well, I have a glare on the TV screen.
When was the last inspection completed?
Yeah,
Was the trip hazard marked with paint?
painting the trip hazard.
Was the sidewalk issue known and was there a plan to repair it? And was there any warning signs? And how long has the concrete been noticeably raised?
Cool. Anybody here in the live audience have anything to add? No? I think that covered it pretty well.
Maybe what was the weather at the time of the accident?
Yeah, what was the weather? That could come into play.
Footwear, I always like footwear.
Yeah. I was gonna say, that was the main thing that I didn't hear from the group was the individual that tripped. What types of shoes were they wearing? Were they running versus walking? Were they
Carrying.
Were they drinking?
Were they drunk?
Time of day.
Time of day? You know, is it midnight and there's not very good lighting?
Carrying something, block their view.
Carrying something, that's another good one. So all of those things, and I think we covered that pretty good. Typically, I think our claims folks, they get concerned anytime that lip is gonna be a half inch or more. So we'll look at some examples of what we see out there. Obviously, this would be a significant concern that we'd want to get repaired. We'd want to give people notice, right? If we can make the hazard open and obvious, we have less liability exposure. Where if it's harder to see, you know, we don't have a painted line, we're going to be potentially more liable. This is one where the district had done work over the years. You can see that by, doesn't work on the TV. They shaved or ground out the edge initially. And you can see that, but anytime this starts to happen, right? We have a tree root that starts lifting it. It's not gonna just stop. You know, so we know that if we're struggling with tree roots, you know, damaging our sidewalks, this is something that we're gonna have to continually maintain to the point of replacement at some time. I think our next photo is a good picture of making that open and obvious, so we know we have a hazard. We use this example in discretionary immunity, you know, so painting it a contrasting color to draw attention to it so people recognize that there's a change in elevation is a good tool. If we painted it 5 years ago and we haven't repaired it, it's no longer a good tool.
So with the law, can you cut a tree down to, you know, if it's a walkway that's used heavily, can you cut a tree down and as long as you replant another tree in another place?
Every local jurisdiction is going to be different. So you really need to reach out to your local city or county, whoever has jurisdiction over your facility, and find out what their rules are. I think what you're going to find is the majority of them, if you have a legitimate safety issue, liability issue, they're going to work with you regardless of what their rules are. And there's chances are they're going to have some sort of replacement where if you cut this mature tree down, you're going to have to replace it with multiple or this, that, or the other. The other thing is there's certain types of trees that are going to be more susceptible to this, right? So doing your research, a lot of cities actually have ordinances that you're not allowed to plant X, Y, and Z trees, you know, near city right of ways because of the issues they cause with roadways and sidewalks. The other misnomer that a lot of even homeowners think is that's a city sidewalk, I'm not responsible for it. Chances are the city says you're responsible for that sidewalk. You know, so don't just assume these sidewalks out here, SDAO is responsible for maintaining those sidewalks. And we're potentially liable if we're not maintaining those sidewalks.
Can you close the sidewalk until you fix it?
I think that's depending on how big the hazard is, I think that's a reasonable solution is,
Here, I mean, I know the public, I mean, enforce them to walk down the street, could you close it?
I think you could, as long as, you know, there was good signage in your time frame. You know, if you were closing it for a month and it's, you know, it should be something that you can fix in 2 or 3 days. You know, I think there's some issues with that. But yeah, I don't know why you couldn't. You'd want to reach out to your local jurisdiction. So here it would be the city of Salem. Say, hey, I have this hazard. We want to repair it. Can we close off the sidewalk, or can you close off the sidewalk and put signs up until we can get the repairs made? It's scheduled for next week on Thursday. And, you know, document those conversations, what you're doing. And I think that's a reasonable.
If you close it down, are you required to provide another?
That's why I would contact the city and have those conversations. Here, I think it's a no-brainer. You got control, you know, we have controlled intersections. They could go across the street. You know, put up signs that say that sidewalk closed, please cross the street. If they choose to walk in the street at that point, that's not the guidance that they were given.
And in most cases, when you start dealing with trees, it's good to get an arborist report on whatever the tree issue is. If it's causing root issues, you know, you can cut the roots and it may kill the tree. So you want an arborist report that would justify why you're doing what you're doing. It kind of helps you there. I know years ago in Beaverton, and this was 15 years ago, if you cut an 8-inch tree, you had to replace, you had to put 8 trees, because every inch of a tree you took down, you had to replace it with another tree somewhere on your property. So, but I don't know if that still stands, and it depends on if it's a hazardous or if it's a dead tree, then you don't have to do anything, or if it could potentially cause harm, something like that could be. Jeff just mentioned something about ADA. ADA issues, if you decide to close it, you know, you might have to have ADA access issues, which would mean you need additional access to your building or wherever if you're closing the sidewalk, and that's the only access. For us here, they could go through the parking lot and come back around to the back door or some other options. So.
Yeah, great point, Jeff. Thanks for sharing. So the last component here with sidewalks that I wanted to mention, and this is something that typically we see more on the east side of the state, and that is the deterioration due to ice melt products. So if you're using ice melt products and it does break down your concrete, you guys just need to have a good process and budgeting for replacement as needed. The other thing is, and I actually have a copy of different types of ice melt and how they interact with concrete and asphalt products. You know, you can spend a little bit more money up front for an ice melt product that isn't going to cause as much damage to your concrete. You know, so you're spending a little bit more up front, but your replacement is going to be pushed further out, which is a huge cost savings in the long run. All right, a Philadelphia restaurant was ordered by the court to pay a former customer $113,000 after the customer slipped on a soft drink and broke her tailbone. The beverage was on the floor because the customer had just thrown it at her boyfriend a moment earlier during an argument. So a playground accident. So we had a young minor fall, break their femur while playing on a park and rec playground. What types of questions and information would we want associated with this incident if you're in charge of investigating it?
Age of the user versus the age requirements of equipment.
Age of the user versus the age requirement, hopefully that we have posted.
Sufficient fall protection.
Sufficient fall protection or fall surfacing material.
What was it? What kind of accident was it? Are the use zones correct? When was the last inspection?
Yeah. So a lot of these are very similar. We might have some little nuances. With playgrounds, fall surfacing and use zones is huge. So did we have the right kind, the right depth? Are we in compliance with industry standard? You know, in this case, the Consumer Product Safety Commission publishes guidelines for public playgrounds. Inspections of the equipment. Was the equipment damaged? Do we have signs? You know, have there been any modifications to the playground that weren't approved by the manufacturer that can come into play. When I first started with SDAO back in 2005, you know, we had some park and rec districts that had some homemade playground equipment, stuff that, you know, was old, wasn't in compliance with the guidelines that are out there. And I think as a state as a whole, we've really moved past that in a lot of areas.
Sometimes it's the child that's doing, my son was swinging when he was in 3rd grade, and he jumping off the swing and did that, and he busted his wrist and broke the growth bone, had to have a pin. So a lot of times it's not necessarily the equipment, but it's the child, how they're playing at recess.
Absolutely.
Yeah.
Absolutely. And with our park and rec districts, typically we don't have that oversight, that supervision requirement. And in that case, on the SDIS side, the district's probably not going to be liable.
Right.
But if we didn't have the appropriate use zone for the swings that they were jumping out of, and we didn't have the 9 inches of wood chips where they landed, regardless if they were jumping, we have more liability exposure and more likely to be liable for that incident when we're not up to those industry standards as well. But that's a great point. You know, a lot of times it does come into play. What were they doing? Were they using the equipment improperly? Yep. All right, so let's look at some playgrounds. So this is kind of a tricky one. Our park and rec districts probably might get this one, but this looks like a pretty decent playground to me. You know, for those of us that deal with playgrounds on a regular basis, this happens to be pea gravel that they're using for a fall surfacing material, which is a rated product, but you have to have 9 inches of loose fill for starters. And pea gravel, at least on the west side of the state, with the moisture we get, really compacts into concrete, and you get about 2 inches of loose fill and a very solid surface. So if we're not maintaining it, there's going to be some concern there. The other part is pea gravel is only rated for a 5-foot fall height. So if we had an individual that fell from the top of that slide platform on the left, is that over 5 foot tall? Probably. You know, if they're injured and they fall from that, we have pea gravel as surfacing. Even if we have our 9 inches of loose fill, we have some more exposure there. We're more likely going to be liable for that incident if there was an injury and they filed a claim against us. Just another example of something that we would absolutely be liable for. You know, if there was an injury on this playground, not having any fall surfacing material, you know, is a pretty big exposure. Here's another example where the use zone just is not the appropriate size. It should be a minimum of 6 foot from the perimeter of the equipment. So again, just knowing what the industry standards are and maintaining our facilities up to those industry standards, it's going to help mitigate that exposure for the entity involved here. And then we mentioned signs. Signs always help. You know, if you had an 18-year-old that was fiddle farting around on this playground and they're injured, it's not appropriate for them to play with. Vice versa, if you have a parent that brings a 3-year-old or a toddler out to play on this playground, we're clearly telling them this is not appropriate for that age group to play on.
On that last picture, Troy, where he showed that wood chips and it was kind of over the sides out on the roadway. Or like having chunk rock, pea gravel that gets kicked out of planter beds or out of those designated areas onto the actual sidewalk. Is that a pretty common?
I wouldn't say from a claim standpoint, we see a lot of claims from those. Do we have the potential there? For sure.
The pea gravel on asphalt's a pretty big one. You have to make really good containment to maintain your pea gravel in there. You throw it on asphalt and then it gets into the buildings and it does wonders when you open a door and pea gravel stuck underneath there. Puts nice grooves into your flooring. But yeah, that becomes like little marbles on the floor for kids to slip and fall on.
But you're also talking about more like an entryway to your office building where you might get some bark dust from your
Right.
flower bed.
Right, yeah, or just, yeah, that small
Yeah.
little river rock that's
Yeah.
And that's
like a
that,
marble.
that's that continuous daily maintenance, as we recommend with, all our buildings is to walk around your buildings on a regular basis
Yeah.
to make sure that things aren't deteriorating, things aren't intruding where they're not supposed to be, and those kind of things.
Where your staff goes, oh, we had a really heavy rain, our gutter overflowed, we need to fix that, but that caused our flower bed to erode right across our walkway into our building. We should be recognizing that at the beginning of whoever's shift
And then it froze, became a solid sheet. of
and
ice.
getting out there and mitigating that hazard, quickly. It's the same thought process with inclement weather, not that you on the coast deal with snow often, but it's happened the last couple of years. Do we have a practice of, getting our walkways opened up so that they're slip free? Same type of thought process there. All right, a citizen from Delaware successfully sued the owner of a nightclub after she fell from the bathroom window to the floor of the nightclub and knocked out her front teeth. This occurred while the customer was trying to sneak through the window in the ladies' room to avoid paying the $3.50 cover charge. She ended up being awarded $12,000 in dental expenses. It's just, it amazes me what people sue for, right? And we see it, maybe not to this level, but we see it. So I think this is going to be our last case study before we move on to Jason's hot topics. So this is going to be a transit district. A person in a wheelchair tips over as the bus goes around the corner, ends up breaking their wrist, gets a facial fracture, and damages the wheelchair as well. So what types of questions or information would we be asking or wanting to see if we were investigating this incident?
How close was the person in the wheelchair to the curb?
So this is actually, the wheelchair was on the bus.
Oh, on the bus, okay.
It flipped over while on the bus, while riding the bus.
Is there a video? Was the wheelchair within its designated area?
Great questions. Chances are this day and age, there
Was
is
it locked
probably
into
video.
a secure position?
How was it secured?
Were proper procedures used to secure the mobility device? Sounds like a transit district.
All great questions.
Based on who that is, yes.
What we haven't addressed right now is the driver itself, right? How fast were we going? How quick did they take that turn? Has this driver had any issues in the past? Do we have a drug and alcohol testing policy related to, post-accident drug tests, and do we follow that? But we do see these, I don't want to say frequently, but I think we get at least one of these every other year or maybe every year. But a lot of times it comes down to training. So our staff formally trained on how to restrain or assist the passenger with restraining their wheelchair. What do those devices look like? Have we inspected those devices? That's typically one of the main things that comes into play. So just some photos of what those devices might look like. The National Highway Traffic Safety Association puts out some recommendations on how those anchorage points should be and all that good information. And that was my last case study. So before we throw it over to Dan or Jason, I don't know who's doing the top topics. Is there any questions from the audience here or anybody online? We'll give you guys a minute feel free to raise your hand or unmute yourself as well if you're online. If you're comfortable doing that, if you have any questions. Nobody in here? Dan's not seeing anything.
You've done such a fantastic job.
let's move this to the other side here so Jason's more audible.
Well, and if you do have questions, feel free to jump in. So I was asked to just give a quick update on some of the hot topics that we're watching within the risk management department. Yeah, I don't have to be on camera. It's fine, Troy. So as you've seen, most of you who've attended these in the past, we are focusing on a lot of basic information, kind of trying to go back to just the basics and build a foundation. Our intention there is we've had a lot of turnover, lots of new people, lots of people in new positions. And so we really felt like there was a need to build that foundation. We have new staff within the risk management department. You all have new staff that has come in due to retirements or people leaving for variety of reasons. And so that back to the basics drumbeat is something that we're going to continue to talk about for quite a while, whether that's employment related issues, setting up folks for success, setting your expectations out, starting with good position descriptions to describe what it is that job actually entails. There's a variety of reasons that we're asking folks to do that, and we're trying to also provide all the resources for you as well. I do know that we just finished our volunteer handbook, so we now have a employee handbook as well as a volunteer handbook. So if you have volunteers within your organization, if you go on to the resource library, it's out there. Just search for volunteer handbook and that should pop up. If not, you can email sdao@sdao.com, right?
Or help at SDAO.
Whichever one it is. And so, and we'll get you a copy of that. I know that for me, on the public safety side, fire districts rely heavily on volunteers. I also know our park and rec districts do as well. And so the intention behind that handbook was to cover a lot of those, a lot of the general information that you would need, and then we'll help you to fill out the more specific things based on your district. And sort of with that. Well, okay. So the other thing is with, again, the changes that are occurring, your key contact is really important. That's the person that we reach out to generally with all the information that comes from SDAO and SDIS. So making sure that you have the correct person in that position is important. Making sure that everything is up to date, that the contacts as people move in and out of positions, make sure that we have the most current contact information for everybody. You're not limited to just one individual, of course. So if you have multiple folks who have different roles and responsibilities within your organization, you can give us that information and we can figure out how to plug them into the different systems that we use, whether it's the insurance portal, whether it's just, email, newsletters, things like that. We have a variety of things that folks can do that. I do know that for Monica's group, the HR Answers group, there is a limit of 2 individuals. And the reason that she wanted to do that was we don't want people fishing for answers. So we don't want just anyone generally reaching out to the HR group saying, hey, I've got this hypothetical. And so you have to be an authorized user to be a part of that discussion group. But it's pretty simple. You let us know who that is. We confirm with the key contact or, board chair, or general manager, somebody who has authority, and then we can take care of that. But again, go back to your key contact, make sure that that is up to date. If you don't know who your key contact is and you want to figure that out, we'd be more than happy to help with that. Again,
Or if you need assistance getting on the insurance portal and getting access to the insurance portal, let us know.
help@sdao.com.
Or risk management at SDAO.
Either way.
No, help is pre-loss. Member services.
Health is everything.
Help is pretty much everything. Yeah. We try and make it somewhat easy. So, and then finally, just some quick OSHA updates, unfortunately. So of course, smoke and heat rules went into effect mid-summer. That may or may not have affected your district throughout, the last few months. Our intention is that you sort of do an after-action review and just see how that affected your district, if there were things that went well, didn't go well, and sort of plan for next year as the wildfire season hopefully ramps down. And obviously heat has kind of gone away. I don't foresee anything in the, in the 10-day, 15-day forecasts that we're going to have some 100-degree weather. It was actually sort of mild this year. Although I did notice that there were a lot more heat alerts that came out from the Weather Service. And they seem to be a lot lower than they have been in the past. So 95 and all of a sudden we had high heat alerts versus past years where it might have been 105. So I think everybody's, monitoring that and becoming more aware of the heat.
Jason, how many citations did you hear of related to the heat and smoke rules, or did you hear of very many?
There weren't a lot. For the majority of the visits, especially for our members and the fire district members or fire department members that I've talked with, the majority of them had more of an educational experience. We'll call it that way. But there were hazard letters that were written. The majority of them were for not having the written program. So something pretty simple as just having a written program, laying out how you're going to deal with the smoke and heat rules. And I think we have some examples from members that were good. We're happy to pass those along. But that was the majority of what I heard was programmatic things, not necessarily how it was implemented. So my experience as a compliance officer in the past, it's you ask for the simple things. So do you have a program? It's a yes or no. Very simple thing to issue a citation for, because you either have it or you don't, and I don't have to dig for it. So so that was really with the smoke and heat. It happened. It wasn't all that exciting, I would say. Troy and I kept monitoring things just to see, for our own internal use as well. And there were some days that were smoky, some days that were hot, but nothing too exciting.
Especially on the smoke side, I really expected there to be more days in Southern Oregon, Eastern Oregon, where staff were going to be required to wear respirators. And we just didn't have that many days. I mean, there was some days, but last year it was 20 plus days for Jackson County. This year we didn't have more than a handful.
Yeah, I think the one spot that I noticed where it was probably the worst was around Oak Ridge. And that's simply because the monitoring station is almost right next door to where the fire is. So that was about the only spot that I really saw be impacted as I looked at the numbers. Every once in a while, there were, a day or two that the wind changed direction, but not too exciting. COVID, yay. So the rules, I reached out to all of our districts and asked you to support making the rules permanent, which just sounds ridiculous. But it was so it didn't roll
Not
back.
public opinion or anything.
Yeah, no, I never have editorial comment on COVID anymore. We were successful, let's put it that way. Our members reached out to OSHA, let them know that we were all in support of making those rules permanent. And the reason we did that was we didn't want things to return back to masking, distancing, all the rules that were in place, because they were temporary standards. Again, weird rulemaking. It's just one of those things where if you don't follow this stuff regularly, it's very confusing. So I appreciated everybody just following along and trusting me on that one. So the rules are permanent. Masking went away for, again, general membership. Healthcare, patient care, that's a different story. So for fire districts, health districts, we still have our rules in place, but everybody else, no masking anymore, no distancing, no enhanced cleaning. If you like the enhanced cleaning, go ahead and keep doing it. But I think the majority of the members that I've talked to so far have decided they really don't want to pay the vendor to, do enhanced cleaning anymore. So they're happy to see that one go away. And then as far as the final item on my list, many of you know that Michael Wood stepped down as the administrator of Oregon OSHA, and they've had a few people sit in that chair. At this point, currently it's Renee Stapleton, who was their policy manager. Renee and special districts have a very good working relationship. So we're pleased with her being in that chair at the moment. At this point, it's still temporary. She's still the interim administrator. My guess is that they will move forward with hiring somebody permanently after the election is over. So, we'll see again who wins the governor's race and what direction that might take the agency. So, any questions, Troy? Anything you can think of?
Well, let's just throw it out to the group first. Any topics that you guys have questions about or want to talk about online or here? While people are putting something into the chat or unmuting themselves, I think it's just worth touching base on property. We are getting to that turning of the season. It's a good time to do our last, not last, our pre-winter weather inspections, our gutters cleaned, or our scuppers cleaned, or downspouts attached, working, plumbed. Do we have our process in place for inclement weather, checking on our buildings, shutting off water, keep maintaining heat, all of those types of things. If that's something you haven't dealt with, and you do have buildings that you insure with us, please feel free to reach out. We got a couple of great webinars. We have some good checklists, some good process documents that we can assist you guys with. And I'm assuming we will be doing a winter weather webinar in November-ish.
November, December-ish.
So, yeah, it's still hot outside, but it's not going to be for long.
Not forever.
Winter is coming,
Seems like that's part of a movie or something.
something.
I don't see anything in the chat. I don't see any hands raised. Anybody? Last call online. Any topics you want to touch base on? All right, just to make sure the audience is still there online. Is the camera blurry, and has that camera been blurry the whole time for everybody, or is that just my computer?
You need glasses now, Troy.
I need
You're
glasses.
getting old.
It's fine, so it's just me.
Okay.
You're right. My boss just called me old. Did we get that on the recording?
No, I stopped recording 30 minutes ago.
Oh, let me get to the chats because we just had a bunch come in. Any word on how talks between SDAO and SAFE are going?
Oh, that's a Dan question.
What's our, no comment is?
It depends.
It depends.
I think the document that Frank sent out last Tuesday, I believe, is where everything's at right now. I'm assuming it's all moving forward and gonna happen, but obviously there's.
Do you want to back up in case some people haven't
Yeah.
seen that memo?
There's a memo that Frank sent out to everybody, and if you would like a copy of it, we can forward it on to you. Basically talking about the conversation between SDO and SAFE to do a partnering of workers' comp coverage moving forward. And it kind of talks about the reasons and stuff in there. If you just let us know you need that, we can send it to you through, might be able to upload it to this, or we can send it to email.
If you want a copy, you haven't seen it, send an email to riskmanagement@sdao.com and we'll get that forwarded over to you.
Is there any others? Just all these blurry questions.
It's blurry for some, but not for others, so that's interesting. We're using a new camera system, that's why I asked. So I think that's it. Want to just thank everybody for attending. Sorry that we had some technical difficulties up front, but thank you for hanging on and we got y'all in there. This session will be recorded and posted to the SDAO resource library, reference resource library, probably by next Monday. So it'll be available on there. And we will go ahead and end the call.
Got it.